If we could just get your name real quick.
Ron O'Brien, Franklin County Prosecutor.
Okay. Ron, what did you think about the sentence?
The sentence was actually one that was jointly recommended by both parties going back to the time of the plea in August. Our goal all along was that there be a period of incarceration or custody, and as Judge Beatty indicated, the fifth-degree felonies under state law are presumed not to have prison time with them. So since the offenses were presumed not to have prison time, what we attempted to do was to negotiate a plea that we required as a condition of probation or community control county jail time, and the 45 days is what was agreed to by both parties. And of course Judge Beatty is not bound by that, but she followed the recommendation, and that was satisfactory to the prosecution.
Do you think other charges will be covered?
Pardon?
Do you think there will be other charges that will be forthcoming?
I can't say that at the present time. Mr. Gutierrez is obligated under his plea agreement to testify before the grand jury if asked, to testify in front of any subsequent pettit jury, and to give any statements to Dave Freel and the Ethics Commission or the Inspector General if necessary. So it's expected he will continue to give information and provide testimony if needed. Whether that results in charges, I don't want to at this time prejudge.
I was just wondering why it was so important to you that it is included incarceration.
Well, as I think again Judge Beatty indicated, under the statute, someone who's in a position of public trust, public honor, public position has a higher standard, and when they violate the law contemplates that they receive a penalty that's commensurate with that public position in violation of trust. And so our thought all along was whatever penalty that was at least agreed to by us, and obviously a judge, if someone pleads guilty and there's no agreed penalty, then it's completely up to the judge. But we all along had communicated to former defense counsel in this defense counsel that it was our intention to ask for a period of incarceration, and actually that's what the Ethics Commission was also in accord with that recommendation.
Mr. O'Brien, Mr. Gutierrez apologized to his wife and to his family, but didn't apologize to anybody else, including those two women that sort of sparked some of these investigations and the taxpayers themselves. Your thoughts?
I guess that's what sparked the investigation. It was not per se a part of this case. This was the criminal side of that investigation. I don't know the status of whether he previously apologized to the people in connection with the civil matters, but while that sparked this investigation, perhaps it was not part of the sentence that happened in here today. I think probably, however, he could have and perhaps should have apologized to the taxpayers and the citizens of the state of Ohio for the shame that was brought upon the Ohio Attorney General's office and the amount of effort that had to go into investigating the case.
Do you think he had any special privileges?
Was able to, Mr. O'Brien was just saying, maybe he'd like to apologize. He didn't hear an apology to the taxpayers.
Well, I think he indicated that he was sorry for a number of reasons, in particular for his family, but he's sorry to everybody that's involved in this. And genuinely and sincerely regrets the situation.
Thank you.
Home, and he will not be doing his time anywhere other than in the Franklin County Jail. I know there was some discussion, but whether it will, I insisted that he pay the cost of that if he was going to do his time up there, that our sheriff would not be required to pay for it, which typically happens if you do your time in another jurisdiction. And we were asking restitution on the workers' comp account, so I didn't want to see us have to turn around and pay to have him serve the time closer to his home, so I insisted that he pay for it, and I think he found that the cost was substantial for 45 days, and so he agreed that he would do his time here in Franklin County, so commencing, I think it's December 4th of this year through March 12th of next year.
Does he
every Friday he'll report to the county jail. He will be kept there through, I believe, Sunday night at 9 p.m.
Maybe a quick question for Mr. Freel. You guys sort of went through the investigative process that brought this to the point that it is right now. How satisfied are you with how things ultimately came out of this.
Well, you're never satisfied to see someone go to jail, but we are satisfied that there's accountability to the public for using public resources for his outside business and having somebody else pay his lodging and the cost of his lodging and loans to his company for public service when he should be on public logs and responsibilities overall. We've worked closely with the Franklin County Prosecutor's Office, with Ron O'Brien, with his staff. Our investigative staff continues to work with them on other related issues, and I think we've tried to hold accountable the folks at the top of the former Attorney General's office where they should be held accountable.
Those other related issues, is Mr. Gutierrez, going to help you with those, you think?
I wouldn't comment beyond what the prosecutor said. He's committed to assisting us in the course of further investigation. He's assisted us to this point in time and has provided statements to our investigators and to the prosecutor's office, but he is committed to testify where the prosecutor may decide that he needs him to testify if other cases are brought.
Now, it's been a year and a half since all this broke. Do you anticipate any further prosecutions, or does this close the book on everything?
Well, as we've said several times, our investigation continues with the Franklin County Prosecutor's Office, and we certainly wanted the chance to talk to Mr. Gutierrez after he entered a plea again just a couple months ago. So our investigation continues. We keep working with Mr. O'Brien's office and his prosecutors and our special investigators, and we'll see what the prosecutor decides is the conclusion of that.
And I would note on that subject that at least for felony offenses, the statute of limitations is 6 years. Misdemeanor crimes, including ethics crimes within the jurisdiction of the Ethics Commission, are 2 years, and the statute does not begin running for a public official or public employee until they terminate their employment. So most of the cases that might be ethics violations that could be brought out of this investigation may be brought within the statute of limitations by my calculations up through May of next year. So I think the investigation does continue, and the statute is something we're cognizant of and would bring any charges that may result from that further investigation within the statute.
And this is really a case of classic wrongdoing where you use your public office and resources, your time, your personnel, your assistants, your personnel to conduct personal business. And in his case, you heard him say he's in the construction business, and not separate your personal life from your public life. And the prosecutor's office, through bringing the charges, has recognized that.
One last question. You said it, but you didn't really say it. We're talking about Mark Dan here. There is no conclusion as to whether he'll be charged at this point. The investigation's ongoing.
Paul, I don't want to mention any persons, individuals, or names, other than to say that the Ethics Commission has not closed their case, is my understanding. We are still receiving information from them. We still have I still have 2 people assigned to the case, and they're still working on it. And whatever charges that may fit the statute and credible evidence or witnesses to support them will be followed wherever it may go.
Thanks.
Hey, the restitution he's paying that was mentioned here today, is that the same restitution that's related to the case that he filed an appeal on this week?
Yes, it is.
How does that work? I mean,
Well, and if he wins his appeal and they say it's not $6,800, it's $4,200, then we have agreed we will all come back to Judge Beatty and ask her to change her court-ordered restitution to the appropriate level. We believe the $6,800 is the right number, but he does have the right to an administrative appeal, and he did file that. He also could withdraw it, and that may be in the realm of possibility. But if he's successful in the appeal and the number ends up being something other than 6826 or 6876, then by agreement we'll reduce his restitution to the judge.
and when does he have to have that paid by? Is there a deadline?
Well, usually the probation department enters into a payment plan over the life of the probation, so it's usually X amount of dollars per month.
Okay.
And they have to pay it over a period of time, and I think she did 5 years probation. That's the longest they can put people on probation for, and typically, if he would pay it in 3 years, then she likely would terminate his probation, because the goal is to always to get the restitution.
Okay. Thank you.